Well, joining us now, the senior Congress leader, Dr. Abhishek Manu Singhvi, this on a day in which Rahul Gandhi has been disqualified from the Lok Sabha. This is after he was found guilty and convicted for 2 years, sentenced in connection with a defamation case against him, which is several years old now. Dr. Singhvi, thanks very much for being with us. You know, Section 8(3) of the Representation of People's Act 1951 is absolutely clear. A person convicted of any offence sentenced to imprisonment for not less than 2 years shall be disqualified from the date of such a conviction. This being the case, does the Congress really have any immediate option other than going to another court? I understand the political points that you're making, but this is a court judgment.
Look, Vishnu, a judgment has come yesterday. A stay of conviction is required. Any stay of conviction requires a judgment to be studied, a paper book made, an appeal made, filed, listed, heard by the other court higher than the magistrate court. In this case, the Sessions Court. It takes time. It takes 3-4 days. Within 1 day, the Election Commission in law may be entitled. Good governance and decency require them to hold their hand for a while, but it doesn't matter. We don't expect that. They have issued a disqualification. The disqualification is based entirely on one premise: conviction. If you remove the foundation, how can the Imarat stand? How can the building stand? So when we get a stay of conviction, which we are very confident of, the disqualification will be dealt with.
No, but Dr. Singhvi, you've accused the BJP or I suppose authorities within Parliament of acting with alacrity, right? That's the word that you did use.
No.
The other way of looking at it,
I use
sir, half a second, correct me, but just listen to the rest of what I'm saying. But the contrary argument to that is that they had no choice.
I'm agreeing with you. I'm saying there's no restriction in law, but the words I used were not my words. The words go to the Supreme Court. In the case of a legislator from UP, see my press conference. In that legislator's case, with post-haste speed, the Election Commission issued a by-election notice.
Okay.
The Supreme Court used these words. Ultimately, didn't get a stay of conviction.
Got it.
So, we had to lose this suit. But they said you are moving with alacrity.
Okay, I take that point. I take that point. You also spoke about 202, right? Where a judge needs to call for a report. There is the entire issue of jurisdiction, and that is it the belief of the Congress? Now you've had 24 hours or so to actually, it's an order in Gujarati. Are you certain that there was no inquiry which was conducted in Kolar?
There are 3 very disturbing features of this judgment amongst many more, but I don't have time for all. One, for a first-time alleged offender, Mr. Rahul Gandhi is given the maximum punishment possible. It is never done. In a 15-minute hearing on sentencing, it is unheard of that you will give the maximum punishment. Obviously, without the maximum punishment, he could not be disqualified. Second, these dates are important before I come to your 202 point. Look at how this complainant is behaving. There is much more than meets the eye. You file a complaint, just 6 dates are important, Vishnu. You filed a complaint in April 2019 in Surat.
Yes.
The magistrate then is one Mr. Dave. Rahul Gandhi appears before that magistrate in June 2021 physically. In March 22, on a pure technicality, the complainant goes to the High Court and seeks a stay and gets a stay of his own complaint.
Right. In
the magistrate's court. He tells the High Court that the procedural infirmity state. This is in March 22. For 1 year, nothing happens. The complainant is happy sleeping. We reach February 23. February 23 this year, 7th February, Rahul Gandhi gives a speech in Parliament and he names certain people, as you know. 9 days later, on 16th February, the same complainant goes to the High Court and says, I withdraw let my trial go on post-haste. On 27th February, after a 1 year plus gap, the trial restarts. On 23rd, we get a judgment. I think this tells its own story.
No, but Dr. Singhvi, I'm hardly the...
Withdraws. 1 minute. Now, in this whole process, where is the time for 202? 202 point noted by the judgment, and yet no 202 done. Point argued before the judgment, no 202 done. Now, in case you don't know, 202 is a special mandatory provision created where it is on the face of it clear that I have an event happening territory X and I am going to territory Y to file, in this case Kolar, Karnataka, to Surat, Gujarat. To decide jurisdiction, he must have an inquiry himself or through the police or direct one. The magistrate doesn't do it. Why? Because everything was state. It's only in the last month that things have been done.
No, but Dr. Singhvi, I'm just a little concerned about, what you mentioned a few sentences back. You seem to suggest that the entire system, with the judges in Surat, there was something wrong with the process, right? It was unfair at many levels. Is that not treading on dangerous territory? I mean, it's one thing to say that you disagree with what they've ruled, but to suggest that there was one judge now, there's another judge then, and that
Let us be clear. Number one, the complainant is paying ducks and drakes. He's keeping the matter pending, prolonged, and lazy. When he chooses, he's making it fast, super fast track when he chooses, especially after Rahul Gandhi's speech in Lok Sabha. The dates show that. I'm talking of facts, not inferences. Number two, the magistrate could not have possibly started the process on 27th of February and done a 202. That is an error. Of course, we are entitled to say it's complete error. The process is wrong, and therefore there is an appeal.
Okay. Let me just ask you a political question, sir.
27th February to 24th March, 23rd March. That's why you commit errors. Thirdly, the magistrate, with greatest respect to him, had no business to impose the maximum punishment.
Okay, you feel that the maximum punishment shouldn't be there at all.